Due respect, my lord, I have filed a writ petition, my lord, on last Friday. So may I pray to get it listed on Wednesday, my lord? Thank you.
Please, your lordship, my lord. There is one matter, not troubling now. It is the main list, the part 2 list. It's a hearing matter, 2017. If it is not inconvenient to your lordship, can it be after a vacation, my lord? Because it's 2017. They are the Employee Water Resources Department and they have been terminated long back.
All right. When we'll do one thing, we'll
Yeah.
have it item number.
Item number. Part 2, I'll just place it before
Alright.
the.
You please give her the number. We'll have it in the next list, part 2 list,
Yes,
and you upgrade it. Next year when the court sits,
yeah.
you upgrade it when you want to do it.
Only what I just praying, if it
Hmm.
is not, can be on 4th of January, my lord. I think Mr. Chaudhary also there, Ken Chaudhary also with us. There's a few petitioners, he is appearing. I am also
All right.
appearing for some petitioners.
All right. Since it is already in part 2 list,
Yes,
it
yes.
will be in the next part 2 list. You make a mention, we'll take it up as an upgraded item,
It's okay.
right? You can make a mention on 3rd and we'll take it out on 4th.
Yes, sir.
May I please note this? Well, these 3 similar petitions for regarding pension matters were filed on Thursday, my lord. But tomorrow also it is not listed, my lord. Can I maybe take out tomorrow, my lord? So day after tomorrow I have some problem, my lord. Otherwise it will be listed day after tomorrow, my lord. Obliging.
May I please, Lordship? I like to mention for a motion item, my lord, Thursday, my lord,
What item?
motion matter.
Thursday.
Thursday.
May I please, your lordship, for listing the.
All allowed, all motion allowed.
May I please, your lordship? Lordship, with the concern, other side, I beg to mention item number 40, your lordship, 40.
Yes.
In this matter, we are awaiting instruction, lordship.
Item number 40.
40.
Who is for the other side?
This A. Chakraborty is there, lordship. We have taken consent, your lordship.
You've taken consent.
Yes, your lordship.
With the consent of the petitioner's counsel, Mr. R.R. Gogoi, Leonard, SC Forest Department, Assam, 6 posting of this matter after the winter vacation, so as to enable him to complete the instruction. Prayer allowed, list accordingly.
May I please,
All
your
right.
lordship? Lordship, item number, I'd like to mention item number 46, lordship. The senior engaged counsel is not available to the lordship.
On the prayer of Leonard Counsel for the review petitioner, this matter stands passed over for the day.
Highly advised.
Lordship may pray for listing of a case, Lordship, in orders column, Lordship, on tomorrow, because the interim order is continue on the till today, Lordship. Then
Please, your lordship. Lordship, I am appearing for WPC 4603. It was last listed on 18/9 but left out, and since it is not listed, prayer for listing.
After vacation,
Before.
after vacation, not now. These things not now.
List for motion item 1.
May I please, your lordship. Lordship will find the order dated 9/8/2023, page 8, operative portion, page 11, lordship. Paragraph 11,
Yes.
12, and 13.
Yes. Yes, what is the violation? SLC doesn't sit.
What is that?
independently.
Within 90 days, it was.
No, SLC will sit in terms of its term, which is identified by a previous judgment of this court. So you should have pointed it out.
No.
If the order was in the next SLC, has an SLC bill hand in between,
That instruction I don't have.
then the contempt will be difficult.
Let me take the instruction, lordship,
Yes,
whether
doctrine
SLC was
instruction.
convened or not.
Yes.
No.
If there is a SLC held in
No.
between, then of course there is a
No.
claim. Otherwise, there is no contempt.
I'll
You can't
instruct.
dilute the contempt
No.
power line. And as lawyers, we should point it out to the court that SLCs sit once in 6 months.
Once in a-
How can they do it in 90 days? You get an order, you take it and you go, but there will be problem here. On the prayer of Mr. Dhar, Learned Counsel for the petitioner, this matter stands passed over and shall now be listed again for motion in the first week of January. 2000.
Okay.
Let me, lordship.
Lordship, this writ petition has been filed against the dismissal order.
Lordship, the instruction sought for was not received, Lordship.
Just a minute, just a minute.
Regarding the pendency of the appeal, Lordship.
So anyway, so dismissal order, we have to issue notice.
My lord.
Heard Mr. V. Kumar and counsel for the writ petitioner. Also heard Mr. S.S. Royal and CGC appearing for the respondents who submits that instructions as called for in terms of the order dated 6/11/2023 are still awaited. Since this writ petition primarily assails an order of dismissal from service issued on 4/6/2020, this court is the, and having regard to the nature of averments made in the writ petition, this court is of the opinion that this matter would require deeper consideration. As such, issue notice of motion returnable in 6 weeks.
All the
Mr. Roy, Leonard CGC appears and accepts notice for all the respondents. No formal notice.
Well,
except for-
obliged, Lordship.
Lordship, here in this case, Lordship, an instruction is sought for regarding the payment of the arrear salary of the petitioner, Lordship.
Hmm.
Lordship, that was not received, Lordship. Can you fix the, after vacation, Lordship, I will.
None appears for the writ petitioner on call. You are there?
Yes,
Okay, he wants a little more time to obtain instruction. Mr. O. Lashkar and counsel is present for the petitioner. Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the state submits that instructions, as called for in terms of the order dated 4/12/2023 passed by this court are still awaited, and therefore this matter be posted for motion again after reopening of winter vacation. If the prayer
May-
is not opposed, same stands allowed. List
May I? The respondent number one is the main responsible party here. It is an autonomous body. Usually, payments are made by the respondent number one. Sometimes government may grant some aid. Notice may be issued to respondent number.
He wants time to obtain instruction, you want notice to be issued. We can issue notice that some more time is required to obtain instruction in the matter. Considering the nature of issue involved in this petition, this court is of the opinion that this is a fit case where notice of motion is required to be issued. As such, issue notice returnable in 4 weeks. You are appearing for all?
No, Lordship, I am appearing from 2, 3, 2, 4, 5, and 6. 2, 4, 5, and 6.
Additional senior government advocate Assam appears and accepts notice for respond numbers 2, 3,
2, 3, 5, and 6.
2, 3, 5, and 6. What about 1 and 4?
I'll take steps for one.
One is the 3 is
Pending
the
counsel
finance.
is not-
3 is the finance.
For finance department.
Miss
RM Barwa.
Miss R.M. Burwal and SC Finance appears and accepts notice for respond number 4. As such, service of notice is deemed to be complete on respond numbers 2 to 6. Extra copies of the writ petition, requisite in numbers.
Extra copies have been provided already.
Furnished to the learned departmental council, if not already done. First, petitioner to take steps for service of notice upon respond number 1 by registered post with AD within a week from today. Yes.
Lordship.
My lord, current salary is stopped, so date may be fixed after vacation. Current salary is stopped.
It is submitted at the bar that the current salary of the petitioner has been stopped and therefore there is urgency in the matter. In view of the above, registered to list this case again on 29/1/2024 as a fixed item.
Obliged.
4 and 5.
My lord, in this matter, I was asked to obtain the medical examination report of the petitioners, my lord. I haven't got it, my lord.
No, first of all, they are holding a certificate.
Yes, my lord.
These certificates says 60%, 50%, whatever it is.
Yes, my lord.
This certificate has been issued by the board constituted by the state.
Yes, my lord.
Now you find that their disability is different.
No, my lord, it is not our finding. We were asked to examine them. Yeah, they were sent by the Social Justice and Empowerment Department. The list, one list, my lord, with the candidates who have been selected, my lord, the list of those candidates have been forwarded to the GMCS authorities for re-examining them, my lord. Because, my lord, in some of the cases, disability, those are not permanent, my lord. So sometimes, my lord, that may vary, my lord. And subsequently, in their re-examination, 2 times, my lord, re-examinations have been done in pursuance of requests made by the Social Justice and Empowerment Department. And then, my lord, the petitioner in item number 4 and 5, both were found to be to have having a disability less than 40%, my lord.
I agree with my learned friend. As per sometimes disability will require your lordship.
My lord, in this regard, in most of the cases, there is
How
personal
many
department. my lord.
cases the item number?
Personal department
Total six.
notification to me.
4 to 9.
Application of OM.
Going to
Nine.
mail.
My lord, I am just placing a written instruction of the personal department.
Hmm.
My lord, there is an OM of 2022.
Hmm.
So, my lord, that I'm just placing it before your lordship. My lord, that the first page, I have the thing, and that green flag is the my lord OM's relevant part, my lord.
Hmm.
5, my lord. My lord, that OM says that certificate of disability, my lord. A person who wants to avail the benefit of reservation will have to submit a certificate of disability issued by a competent authority. Such certificate, in the event of selection of such person of any post, will be subject to such verification, re-verification of as may be decided by the competent authority, my lord. So, my lord, there is an OM of the personal
So
department.
all of them, they've been found to be below the,
My lord, I have obtained instruction in respect of petitioner of item number 4 and 5, my lord. They have been re-examined, my lord, 2 times, my lord. One is with a hearing impairment and other petitioner with locomotor disability, my lord. They have been found to be below 40%, my lord.
now you are appearing in all the cases.
Yes.
All the
No,
cases you are appearing,
No, I'm appealing for 4 to 9, all the cases.
4 to 9. So we'll ask them to communicate to you what is the finding of the board.
My lord.
And you, if you are aggrieved, you challenge it because
Yes, my
today,
lord. My lord, in
if
respect
your,
of
just a minute, if your disability is less than, then that fact has to be brought on record. It may be correct, and then only you will know what remedy you can avail. So we can close these matters today, saying that you communicate to the
Yes,
respective
That has to be
petitioners
done.
the finding of the medical board,
Yes.
yes, my lord.
so as to enable them to avail appropriate remedy
Yes,
as may
yes,
be
ma'am.
permissible under the law. On such communication, you can agitate your grievance in the
Yes.
appropriate forum. Some petitioners may not like to challenge it, some may like to challenge it. You understood?
Hmm.
So we'll dispose of all these cases.
Actually, my senior is.
Oh, now I'll allow these cases now.
That is not.
No,
Yes.
take your seat. You've had enough. Take down. Heard Miss N. Day Learned Council appearing for the writ petitioners in this batch of writ petitions. I've also heard Mr. R. Dhar, Learned Additional Senior Government Advocate Assam. Miss R. M. Dekar, Learned.
1 and 2.
My lord, I am appealing for only personal department here.
Acha, for the Ms. R. M. Dekar, Learned Standing Council, Social Welfare Department, Social Justice Department, appearing for the respondent numbers 1 and 2. Mr. R. Dhar, Learned Standing Council, Personnel.
No, my lord, additional senior.
Additional Senior Government Advocate Personnel Department, and respondent 1 and 2 is not required. And Mr. D.P. Bora, Learned Standing Council, Health and Family
Family
Welfare Department. First up, the issue arising for decision. Now, the controversy arising in this batch of writ petitions are common, and therefore these cases have been bunched together. First up, the writ petitioners in all these cases are holding disability certificate issued by the competent authority under the Department of Social Justice, indicating the degree and nature of their disability. On the strength of these certificates, the petitioners had taken part in the recruitment process initiated by the department, which department? This recruitment was initiated by whom?
Various departments, my lord.
By various departments for filling up a number of grade 4 posts. Full stop. The grade 4 posts, full stop. The applicants, the writ petitioners stroke applicants had applied for appointment against the quota reserved for persons with disability, bracket W, P, small w and D, capital P, small w and D, full stop. However, after the selection process was over, the writ petitioners have once again been asked to appear before a medical board
Yes, my lord.
so as to verify oblique reassess the disability suffered by each of these candidates. Full stop. Aggrieved thereby, the present writ petitions have been filed inter alia contending that since the petitioners are holding disability certificate issued by the competent authority, there is no further justification to subject the petitioners to a further verification public reassessment by a specially constituted medical board. First up, taking note of the grievance expressed by the petitioners, this court had directed the Learned Standing Council, Health Department, Assam, to obtain instruction in the matter. First up, accordingly, today when the matter is called up, Mr. Bora submits that the role of the Health and Family Welfare Department is only to the extent of constituting medical boards so as to assess the nature and extent of disability of such candidates on the request of the nodal department, which is the Department of Social Justice.
Yes, and
First up, on such verification, it has been found that the disability of some of the candidates has been less than
benchmark of
Huh?
benchmark of 40%.
benchmark of 40% disability. First up, Mr. Bora submits that the outcome of the assessment already forwarded
Yes, my lord.
has
already
already
forward.
been forwarded to the Social Justice Department,
Yes, Justice and Empowerment Department.
Social Justice and Empowerment Department. Mr. R. Dhar and Ms. R. M. Deka, Learned Standing Council for the respective departments, have submitted that in many cases, it has been found that the disabilities do vary, and hence this exercise. First up, by producing a copy of the OM dated 21/5/2022 issued by the Government of Assam, Department of Personnel, Dispute, more particularly clause 5 of the OM, Mr. Dhar submits that it is permissible under the law to subject the candidates to verification, re-verification of their disability through a competent mechanism, and hence this exercise. First up, after hearing the Learned Counsel for the parties, this court finds that although all the petitioners are holding disability certificates which projects them to be candidates suffering the benchmark disability, yet the subsequent exercise conducted by the department by constituting a special medical board appears to contradict the said projections in the aforesaid certificates. First up, it may be a case where the extent of disability of some of the candidates have undergone change in the meantime, or there was some error in assessing their disablement either by the original authority or by the specially constituted medical board. However, this said aspect of the matter cannot be gone into unless the petitioners are communicated with the decision of the authorities in this regard, thereby giving them an opportunity to assent such decision if so advised. First up, as such, by directing the respondents to communicate the decision of the authorities pertaining to their individual disability status vis-a-vis their claim for appointment against the grade 4 posts, in writing within 2 weeks from today, these writ petitions stand disposed of by granting liberty to the petitioner to assess the decision of the authorities, if so advised. You are also appearing? At a state level recruitment, at the standing council state level. So if, once they communicate it, until such exercise is completed, the process of recruitment is going on.
Yes, my lord.
Huh?
Some of them have been already appointed.
So we'll see, because this is a court order, we'll see when, if you succeed. But if your clients are found to be not meeting the benchmark, all that can be done is a third board. If they don't succeed, it's over, nothing can be done.
But some others matters are also there with similar issue, my lord.
But those are not listed today.
Listed before your lordship today, my lord.
Which are the cases?
Item number 7, 10, 11, 12.
7 is already a part of this.
Yes.
In my case, my lord, I have challenged that decision, my lord. And in my case, my lord, item 10 to 10, 11, 12, 13.
No, but have they communicated to you? What is the finding?
Not communicated, but on the ground that I have not, therefore I have not been.
No, there is a OM which permits this. You have not challenged the OM. Show him the OM, please.
Well, then I'll adjourn for day, my lord, because there is also notification also the appointing the competent authority, my lord, in this.
So you will not be able to challenge anything unless you are made known about the outcome of the process. That is the reason why the direction to communicate to your clients individually. Whether you have been found to be able, disabled, nobody knows.
Yes, but my humble submission, my lord, and even if, my lord.
Then we'll issue rule and examine it in due course. That will cause great damage to his client, but he is not understanding. Huh?
Then communicate.
No, you can't challenge this decision in a vague manner. The authorities will verify. They are entitled to verify. You can't say that, no, you can't verify. Once you have given me a certificate, that's the end of the matter. If there are justifiable facts, they can verify. That judgment we can pass today in your case also. But if you can show that this exercise is arbitrary, then we'll interfere. The courts, the writ courts only interfere in arbitrary exercise of administrative power, not otherwise. If they are doing something which is permissible under the OM, if the decision has a rationale, they can do it. The court is not here to put a spanner in every action of the government. They know what is the reality. Maybe people have obtained these certificates by some malpractice, foul play, who knows? So without the outcome of the process, you cannot even argue your case. You have understood? You cannot even argue. If your client was given a 60% disability and now it has been found to 40%, one ground could be you can say that there can't be 20% variation. But today you can't even argue that. So the arbitrariness ground is not there for you. And if it is not there for you, your writ petition will be dismissed. You want it today as a disposal or a dismissal after vacation. You choose. But by that time it will be over.
Within a time frame,
15 days.
Yes,
And then SK Roy and both. Other numbers also.
Wait.
And 43 also.
And 43. In item, in admission, there is one matter, there is a termination order also.
That will deal separately.
Great.
Actually, you type out 2 different orders. One give SK Roy's name, another in ND. But the court is not expressing any opinion on whether the findings are correct or not.
Yes. Yes.
So it will be without expressing any opinion on the findings and observations of the medical board. This matter is disposed of and
Item 14. May I please your lordship?
yes,
Lordship, the petitioner his hearing is agreed for non-consideration of his promotion, lordship. The petitioner had joined his services as investigator in the year 1990, and his services was regularized in the year 1991, lordship, and his date of joining and appointment is also considered as 14/11/1991 onwards. Thereafter, lordship, in the year 2019, he had
he joined as what?
investigator, lordship, in the office of Deputy Director, Town and Country Planning.
Yes.
Lordship,
Alright.
in the year 2021, page 33, lordship, there was a inter-se seniority list, lordship.
Page 31.
Page 30. Lordship, page 33, lordship. Page 33 is the type copy. Serial number 9, Sri Indrajit Talukdar, date of birth, date of joining, and lordship may kindly see the date of superannuation is 28/2/2023, lordship. It has been reflected in the inter-se seniority. Thereafter, lordship, page 35, a letter was issued whereby the petitioner was informed regarding his correct date of superannuation as 31/3/2023, lordship. That was revised, lordship, and it was held as 31/3/2023, and he retired on 31/3. Lordship, in between, there was a selection committee meeting, and a person junior in the petitioner were given promotion to the post of research assistant to the next higher post. Lordship, 2 days prior to his retirement, the office order was issued on 29/3. And thereafter, lordship, the petitioner had retired on 31/3, and thereafter he approached the authorities for consideration of his promotion, lordship. There was an impugned letter issued
So
by
after
the
retirement, he has approached for promotion.
after retirement, lordship. Lordship, because while the selection committee proceeded with the selection of the person junior than the petitioner, he was in service at that time. But
That's right,
because of
but
the-
he cannot be promoted today.
But
He's not in service. How
But
will
his
he?
pension may be fixed, can be fixed, lordship, because all his life he has worked as an
No, no.
investigator, lordship.
See, listen, try to understand.
Lordship,
There is a legal issue here.
lordship,
Your client may have a grievance.
lordship.
That's another thing. But only those grievance which can be legally handled, those are only going to be considered by the court for delivering justice, is it not?
Lordship.
So if your client would have approached this court that, look here, I am eligible for being considered for promotion, but they are not doing it, then the court can think of some order. He has sat quiet till he was in
He
service.
was not aware, lordship. He
What was he not aware?
He came to know only when the letter was issued regarding his superannuation on 6/12. And thereafter the meeting was held, lordship. And 2 days prior to his retirement, only the office order was issued. He retired. In 2 days, he could not do anything. Thereafter, he approached.
Office order was issued saying what?
Lordship, the order of promotion to the juniors, lordship, office juniors, to the that was issued 2 days prior on 29/3, lordship. That is at page
All right,
44,
they
lordship.
issued notice. Pardon me, say Talukdar and counsel appearing for the petitioner. The petitioner hearing was appointed as an investigator under the Directorate of Town and Country Planning, Nalbari, Assam, way back in the year 1990, and his services were regularized with effect from 14/11/1991. The petitioner retired from service on attaining the age of superannuation with effect from 31/3/2023. The grievance of the petitioner is that although he was entitled to be considered for promotion to the next higher post, just 2 days prior to his retirement, the authorities had held a DPC and surreptitiously promoted his junior by ignoring the case of the petitioner for no rhyme or reason. Hence this writ petition. First up, although the petitioner has already retired from service, Ms. Talukdar submits that if his client succeeds in this writ petition, he would be entitled to the benefit of pay and allowances in computing his pension. Full stop. Mr. J.K. Goswami, learned additional senior government advocate Assam, appearing for the state, prays for 6 weeks time to obtain instructions and file affidavit. Prayer allowed, around 6 weeks. All the respondents extra copies. But you have to do hard work for this.
Lordship,
Where are the judgments? Where are the law?
Lordship. Much obliged, Lordship.
My lord, present husband of the petitioner was an employee of employee of BSF. And during his service, he was dismissed from service on 4th October. And while the preparation was made to prefer an appeal before the competent authority, unfortunately, he was died. And thereafter, my lord, the wife of the present, that deceased wife, who is the present petitioner herein, approached the competent authority by yours two representations, which has not been considered till date, though the respondents have communicated two representations that subjected to disposal of statutory petition made by the deceased husband, that can be considered, which your lordship will find at page 53 and 54 of this petition.
Lordship may issue notice, let me take the instruction, Lordship.
So the petitioner wants to pursue the appeal.
Whether that has been filed, that is not clear for them pleading,
So-
Lordship. Whether his late husband,
At the best, my lord, it can be, lordship may direct
and
the
they have not
respondents to,
challenged the dismissal also.
yes, to pass a speaking order on the.
No, this speaking order, forget it. That is the appeal.
Lordship,
Appeal is against the order of dismissal.
let me take the instruction, Lordship. May issue notice.
Will issue notice at this stage?
But
Huh?
consideration of the prayer of the petitioner should not be barred to subject to this repetition pendency.
All right. Pendency should not be a bar. All right. Heard Mr. A. Pal, learned counsel appearing for the petitioner. Also heard Mr. B. Chakrabarti, learned CGC appearing for the respondents. Full stop. The deceased husband of the petitioner who was serving as head constable, is it?
Yes,
Head constable under the
68
BSF
battalion,
was
Yes.
dismissed from service by order dated
4/10/22.
4/10/2022. Full stop. Although the petitioner's husband had preferred an appeal before the appellate authority.
Not appeal, not appeal. In the meantime, there was some proceeding of the respondent that after receipt of SSFC proceedings copy, then the dismissed employee can prefer an appeal. But unfortunately, he was died in the
Right.
meantime.
But before a formal appeal,
Yes,
formal statutory appeal could be preferred by the deceased, by the husband of the petitioner. He died. Unfortunately, he died, as a result of which no appeal could be filed. First up, subsequently, the writ petitioner, being the wife of the deceased, had approached the authorities by submitting representations with a prayer to, what is the prayer? In the
Pension.
for release of pensionary benefits.
For release of pensionary. How can you get pensionary benefit?
Unless dismissal is satisfied, Lordship.
You have to prefer an appeal against the order of dismissal.
That's why we are waiting for their speaking order, but due to non.
You are waiting for something which you'll never get. Mr. Paul, perhaps you need to rethink about your legal advice.
If your lordship
Alright.
suggests.
Representation with a prayer to provide with pensionary benefits on account of the deceased husband of the petitioner. Since no order has been passed in the said representation, the instant writ petition has been filed. After going through the averments made in the writ petition, this court is of the prima facie opinion that unless the order of dismissal from service is interfered with, the question of releasing the pension of the deceased employee may not arise in the eye of the law. First up. However, there is nothing pointed out to the court which presents the petitioner as the legal heir of the deceased employee to prefer a statutory appeal before the authorities in accordance with law against the order of dismissal from service. First up. At this stage, Mr. Chakrabarti, learned CGC, prays for some time to seek instruction and address this court on the aforesaid legal issue. A prayer is allowed. Issue notice of motion returnable in 4 weeks, since Mr. Chakrabarti has appeared and accepted notice on the all the respondents, no formal notice is required to be sent in this case. Extra copies of the repetition, requisite in numbers, be furnished to the learned departmental counsel so as to enable him to honor. Mr. Paul, you need to do some study. What you are asking for is misconceived understanding of law. It doesn't happen like that.
Item 16.
Please, Your Lordship, this is case for compassionate appointment. Petitioner hearing.
You decide when we'll dismiss it, because 2000 father died, now
Yes,
compassion,
yes.
obviously will dismiss this case.
Because.
Only thing is you can decide when you want the order of dismissal.
No, Your Lordship,
This
because.
is, what is this joke happening here? After
But cause of
23 years-
action is continuous.
How?
Because petitioner hearing also approached this honorable court before, earlier also. So whereby he approached this honorable court for non-consideration of his case.
We'll
Wherein,
consider it after 10 years, after
no, Your Lordship, there is a cost, kindly look into it for a minute,
Yes,
I will
yes.
appreciate it. Earlier he is approached before this honorable court for non-consideration of his case. Wherein the respondent authority has came up with the explanation that there was no DLC meeting could not be held DLC meeting in the district of Lakhimpur. So this honorable court directed the respondent authority to convene a DLC meeting and to consider the respondent petitioner's case. Thereby, the respondent authority held a DLC meeting and considered the case of the respondent authority, and his case was forwarded to the SLC. Now, SLC meeting was held and his case was rejected on the ground that a minimum of 3 years of service was not there to apply for the compassionate appointment. But that clause was already been struck down by this honorable court in various cases, Your Lordship. I have annexed those cases.
Mr. Saikia,
Yes.
no direction for appointing the petitioner on compassionate ground can be issued today on account of the fact that his father died in year 2000. That is what we are going to hold today. You make your submissions. Whatever you want to argue, you argue.
But my case is that there was no fault on my part. I always pursue with the respondent authority and whatever.
All right, heard Mr. Yu Saikia, I counsel for the petitioner, peruse the amendments made in the writ petition. Issue notice returnable in 8 weeks. Ms. S. Sharma, learned standing counsel.
Health Department, PWD Department.
PWD Department, Assam appears and accepts notice for respond numbers
1, 3, 4, 5, and 6.
1, 3, 4, 5, and 6. Ms. M. Bhattacharya, learned additional senior government advocate Assam,
Respond 2.
has appeared for respond number 2.
2, Lordship. Only 2.
Only 2. As such, service of notice is complete in this case. Extra copies will be furnished. This case for admission after 8 weeks. We'll dismiss it together, not today.
Item 17.
May I please? So this is a second round of petition of matter of compassionate appointment. My lord, after this honorable court, my lord, DLC.
Lordship, here in this case also, Lordship, on 19/4/2014 died, applied on 25/4/2014, and writ was filed, Lordship, on 2021, Lordship. And Lordship, in the petition itself, not specifically mention any paragraphs regarding the primary requirement of OM 2014 in clause 1, Lordship. That is required for.
Where is the order dated 8/12/2021?
My lord, 8/12. My lord, page number 36, my lord.
You are appearing for whom?
Lordship, all the respondents.
All right, 8 weeks. Mr. D. Gogoi.
Notice issue, my lord. Issue notice. Hello.
Please, your lordship. All right, I take your lordship page 25, my lord. My application for compulsory appointment was forwarded by the executive engineer on 1/7/23, but till today, my DLC has not placed the matter.
Who is appearing for the respondent? Mr. S. C. Yusuf.
Water Resources, Central Assam Investigation Division.
Who is appearing for whom? Nobody is appearing.
I am for 5.
Nobody is appearing for State of Assam Water Resources Department.
I'm so.
Then why aren't you saying that? Huh?
One.
156.
And 6.
135 and 6 so and so and Ms. M. Bhattacharya. J. Gogoi, Jesse Gogoi, is it?
J go.
J. Gogoi.
Three also,
1, 3, 5 and 6.
1, 3, 5 and 6. Why not 7? Huh?
7 is not here.
7 is not Water Resources Department.
No, in our.
There is no 7. Some vanishing act has happened. No 7. Ms. M. Bhattacharya and G. Assam for respond numbers 2 and 4. Services complete. Extra copies.
I can write it.
We need extra copy.
7, 9.
Where is the washing, my lord? Because this institution prefer, my lord, challenging the order dated 31/12/2018, my lord, whereby petitioners awarded a punishment of reduction of rank, my lord, which was modified later on 33,000 to 25,000. Earlier, I preferred a writ petition, my lord, challenging only the non-consideration of the revision. And accordingly, that was withdrawn, my lord, liberty to file again. Your lordship's order is there, my lord, page 50, my lord. Relevant portion, page 51, my lord. So accordingly, the matter to be decided on merit regarding the punishment matter.
Will issue notice that.
Yes.
Had Mr. H. Chaudhary and counsel for the writ petitioner peruse the amendments made in the writ petition to notice of motion returnable in 8 weeks. Who is the CGC? Since Mr. B. Chakravarti, learned CGC, has entered appearance and accepted notice for all the respondents, no formal notice is required to be sent in this case. Extra copy of the writ petition be furnished to the level of Departmental Council. The requisite in numbers so as to enable him to obtain instruction. Let this writ petition be listed again by reflecting the name of Mr. B. Chakravarti and its CGC in the cause.
Okay.
Item 20.
With busy lordships.
Yes.
My lord, completion appointment, my lord. My lord, petitioners, kindly come to page 44, my lord. One moment, my lord. Here, my lord, the under secretary, my lord.
That in 2007.
My lord.
Yes. Who's so and so 8 weeks? Your name, please?
Yes, sir.
You're for?
I'm for PWD department. PWD.
I want the
1,
respondent.
3 and 5.
1, 3 and 5. And Miss M. Bhattacharya? 2 and 4. That's all? Extra copies.
Extra copy.
We'll club all these cases together.
Yes, yes, sir.
and dispose it of very soon, immediately on reopening.
Item 22.
May I please your lordship? My lord, I was the video of that particular block development. And certain works were there and the aggregated engineers were given the supervision power. And there is a project director. Ultimately, there was an inquiry, but in the inquiry, nothing, no anomaly in respect of the monetary aspect was found against me. So, but they were unhappy with my service as the block development officer. So they moved file before the CM for transfer. But when the file was moved, the Honorable Chief Minister of Assam then with a stroke of pen just asked him to go for, consider him for compulsory retirement. In the process, the person is compulsorily retired without adhering to the settled principle of law that his entire service career was not considered before putting him into the compulsory retirement. And another thing, there was no corruption charge against him. Only that particular work, 2 works were considered while putting him in under compulsory retirement in such a harsh manner. So this imposition of major penalty for that work was not called for.
Right, we'll examine the matter. We'll issue notice. Yes, heard Mr. J. Abedin, counsel for the writ petitioner. being internally aggrieved by the order dated order of major penalty dated 16/9/2023, imposing the penalty of compulsory retirement from service upon the petitioner. The instant writ petition has been filed, inter alia contending that the impugned order has been passed in violation of the statutory provisions as well as the principles of natural justice. I peruse the grounds taken in the writ petition. Mr. N.K. Devnath, learned SC PNRD Assam, prays for time to obtain instruction and file affidavit in view of the above NOM 6 weeks. Since Mr. Devnath has appeared and accepted notice for numbers 1, 2, 3, and 5. And Ms. M. Bhattacharya, learned additional senior government advocate Assam for respond number 4. Service of notice being complete in this case, extra copy of the requisiting numbers, etc.
Diploma.
In this case, Lordship, the petitioner in the year 1995 had joined as Master Workers Lordship, and subsequent on 13/7/1995 Lordship, he was upgraded to the post of section assistant. And I've annexed the document, it's annexure 1, page number 19. And since then, Lordship, since 1995, he has been pursuing the respondent authorities for regularization of his service, because nothing has happened. Now on, in the year 2020, Lordship, I annexed that document also, it's annexure 2, page number 20. The respondent number, page number 20, Lordship.
Yes.
Annexure 2. Ashok got it. The respondent number 8 has issued one notification for regularizing service of 48 this work charge section assistant Lordship. And here in this case, I made a specific statement with regard to that fact Lordship. Some of the persons who had joined at this time when the petitioner had joined the same service Lordship, but the case of the petitioner has not been considered. And I've submitted several representations. And one of the representation I've annexed is at page number 22, but nothing has happened till date, Lordship. So this is the basic grievance of the petitioner, Lordship.
At this stage, Lordship will issue notice, Lordship.
Take down. Heard Mr. S.P. Chaudhary, learned counsel appearing for the writ petitioner. Peruse the amendments made in the writ petition. The petitioner herein had apparently the petitioner herein was apparently engaged as a masteral worker on 1/3/1995 under the Kochugao PWD bracket roads bracket roads division under it is under Kokrajhar division.
Yes, Lordship. At that point of time, it was under Kokrajhar division, Lordship.
PWD Kokrajhar division and was subsequently upgraded to the post of work charge section assistant with effect from 13/7/1995, alleging arbitrary and discriminatory treatment meted out to him on account of the fact that while the services of other similarly situated work charge employees have already been regularized by the authorities, no such order has been passed in his case. The writ petitioner has approached this court by filing the instant writ petition, seeking a writ of mandamus. Full stop. Mr. P. Nayak, learned standing counsel PWD,
In this case, I am appearing for BTC, Lordship.
and standing counsel BTC,
7, 8, and 9.
prays for some time to obtain instruction in the matter. Issue notice of motion returnable in 6 weeks.
Lordship.
6 weeks. Since Ms. S. Sharma, learned SC PWD Assam has appeared and accepted notice for respond numbers 1, 2,
4 and 5.
4, 5.
1, 2, 4, 5.
Yes.
Lordship for
And 9.
9. No,
And 9.
BTC. 9
Who's for
BTC.
finance?
BTC 9 BTC.
Lordship, may kindly record respond number 3, A.S. Alia's name, Lordship, for finance. 9
Mr.
BTC.
H. Earlier, learned SC Finance for respond number 3. And Mr.
9.
P. Nayak, learned SC BTC for remaining respondents. Finance, PWD and BTC, that's all.
Lordship, yes, 3 respondents, sorry.
No, you are for the,
Says for
Achha, Miss? Achha, whose name should I record? Mark it out as respondent number 10. And Mr. P. Nayak, learned SC BTC for the remaining respondents. Service of notice is deemed to be complete in this case, extra copy of the petition, requisition number, etc.
Obligation.
Item 24.
Obligation.
Matter is pertaining to compulsory appointment.
2009, Lordship.
2009.
Yes, Lordship.
So we'll treat all these cases together in a
Lordship.
bunch. Mr. A. Ali, so sorry, sir. And who is for the,
Lordship, I am
It is for the-
on behalf of respondent for although here in this case, the chairman DLC is not make party, Lordship. Only deputy commissioner is the party. On behalf of the deputy commissioner, I can take the.
you, in all these cases, you write, the issue raised in this writ petition pertains to the prayer for appointment of compassionate appointment. In all the previous cases. Then you have for respondent, Mr. J.
Four. Lordship, deputy.
I for 1 to 3, 1, 2, and 3. Lord.
Then Mr. N. Upadhyay, and SC, Irrigation Department, Assam, accepts notice for respondent numbers 1, 2, and 3, and Mr. J.K. Goswami, and additional senior government advocate, Assam, for respondent number 4, complete, etc. etc.
Lordship.
Service is complete.
Item 25.
In this case, Lordship, my junior has been placed above me in the gradation list for promotion from LDA assistant, junior assistant to senior assistant. I'm taking your Lordship directly to the gradation, impugned gradation list at page 24, Lordship. Page 24.
Yes.
My name has been shown at serial number 2, Srimati Nanda Das. And Lordship will see the 6th column, initial date of joining in service, 7/5/1994. And thereafter, in the next column, written initially in the office of the DFDO Silchar and transferred to Dima Hasao Haflong, then again transferred in the office of the DFDO Kachar Silchar on 1/1/2021. Since then, I have been working in the present office, and date of joining present office 1/1/2021. Now, Lordship will see the lady at serial number 1, Purobi Nath. She is the respondent number 6. Her initial date of joining service is 30/12/2004, Lordship, 10 years after me, Lordship. And her date of joining in the present office, 30/4/2004, that is same date she has been continuing in the present office, that is 10 years after me. Now, Lordship, that is my case, Lordship, limited case, that she is 10 years junior to me, but even then, Lordship, she has been placed above me in the gradation list for promotion for junior assistant to senior assistant. Now, this gradation list has been communicated to me by letter dated 2/11/23 in the previous page, Lordship, page 23. I have been given 3 days time to submit my objection, and I have accordingly submitted my objection at page 25. Within 2 days, I have submitted page 25, 4/11/23. Now, Lordship, they have not communicated to me anything, and my instruction is that, Lordship, they are carrying out a process of promotion.
So
and
we
they-
ask them to dispose of the objection. Before that, this gradation list is not to be acted upon for any purpose.
Lordship,
You don't have the instruction, perhaps.
yes, the fishery department matter, Lordship. May kindly fix the matter Friday also. I
No,
can. My lord.
let them, where is the objection?
Objection,
My objection, page 23, Lordship.
in
Lordship, my
25.
25.
It's written received dated 4/11/2023, but no shield and signature here. So I have a doubt, Lordship, whether she has filed the objection before the time period or not.
Lordship, seal is there. It is there. It has come light in the.
Take down, heard Mr. G.J. Sharma and counsel appearing for the writ petition. Also heard Miss M.D. Boral and
Standing counsel, fishery department,
Fishery Department, Assam, appearing for the respondent numbers
1 to 5.
1 to 5.
6 is the private.
The writ petitioner herein is presently working as a junior assistant, bracket LDA, in the establishment of District Fishery Development Officer Kachar, being aggrieved by the provisional gradation list of junior assistants, wherein the respondent number 6, who is junior in service to the writ petitioner, has been shown above her, the instant writ petition has been filed, inter alia contending that the respondents have arbitrarily assigned higher seniority to the respondent number 6 in the gradation list. Mr. Sharma submits that immediately on receipt of a copy of the provisional gradation list, which was forwarded on 2/11/2023, his client had submitted a written objection dated 4/11/2023, protesting about the anomaly in the gradation list. However, notwithstanding the receipt of the objection, the respondent number, who's the respondent to act? We did. The respondent number 5 has not taken any action in the matter. On the contrary, the petitioner has learned from reliable sources that efforts are on to promote the respondent number 6 to the grade of senior assistant. Is it?
Yes,
Senior
yes, yes,
assistant?
yes.
On the basis of the anomalous gradation list as circulated by the departmental authorities. First step. Ms. Bora, learned SC, Fisheries Department, Assam, submits that some time be granted to obtain instruction in the matter. Be that as it may, having regard to the nature of grievance expressed in this writ petition and the submissions made at the bar, this court is of the opinion that the objection submitted by the writ petitioner would have to be disposed of by the authorities before finalizing the gradation list. It is only thereafter the question of promoting the candidates on the basis of the gradation list would arise. Therefore, without expressing any opinion on the merit of the claim of the petitioner, this writ petition stands disposed of by providing that the objection submitted by the writ petitioner be dealt with, submitted by the writ petitioner, protesting against the higher seniority assigned to the respondent number 6 be dealt with and be disposed of with a speaking order before finalizing the gradation list. First up, until such time the aforesaid exercise is completed, no promotion on the basis of the impugned gradation list shall be given to any of the departmental candidates. First up, facilitating the above exercise, the petitioner to produce a certified copy of this order by enclosing a copy of the objection dated 4/11/2023 before the respondent numbers.
4, my lord.
4.
The
Four,
director.
Before the respondent number 4.
Director. Which will be there.
4 is director.
Then director is the authority. Deputy director is the party lordship. Director 3 is the.
3, lordship, 3.
Respondent number
3,
3.
3.
My lord, Lordship may kindly observe if any order passed regarding this objection, this may be communicated to the petitioner.
Whatever is the outcome of the exercise, the same be communicated to the petitioner in writing.
Obliged.
Item 27.
In this case, lordship, there is a mistake, lordship. In the respondent number 4 has been wrongly made a party, lordship. In fact, in case of respondent number 4, some other person's name, lordship, so I may be allowed to file an impleading petition, lordship.
You want to file an impleading?
Yes.
But even if you implead, there will be no pleading. I think it's better you withdraw and file a fresh.
And better to file a fresh, lordship. Yes.
On the prayer of Mr. Ganguly and counsel for the petitioner, this writ petition is permitted to be withdrawn with liberty to file a fresh. Mr. J. Henry, learned SC Revenue, is present on behalf of the official respondent.
Item 28.
Yes, Mr. Bukan.
This is relating to an appointment of a notary. 2017.
Appointment of?
Notary public. 2017, the process starts. 2018, 3 candidates were called for interview. The process was subsequently stalled by 2 writ petitions that were filed before the High Court. Subsequently, the same process that was started in 2017, where I had already received a call for the interview, was resumed again in 2023. Subsequently, an interview board is appointed. In May, 16th of May 2023, I participated in the second round, which is the interview. Subsequent to this, I have been rejected, and respondent number 7 now stands appointed in that. I then filed an RTI in us asking the reasons why this interview, my marks were lesser than, or why was I not qualified. Subsequent to this, I have come to know that on 2nd of June, subsequently to the interview board, they have now conducted the minutes of the meeting, and they changed the entire conduct of cut marks as well as the process that was adopted in 2022. Now, subsequent to that, I filed a review, the review under Section 8 of the Notary Act. That is pending. This has still not been decided. Subsequent to that, the gentleman who is appointed in the board is now being appointed for certain violations, which I have already pointed out in the writ petition, which will be my second leg of argument. I said he is not even competent to sit in the board. Subsequently, I filed another RTI. In the RTI, I sought for 2 information. Number 1, was there any exemptions granted because of the fact that this gentleman is in the board? Number 2, the procedure that was adopted prior to 22, the process is for 2022, 40% marks, 35 is the qualifying. On 2nd of June, after the interview panel was set, and I had already sat down for the interview, the entire process now since changed, and a 50% mark was evaluated, on basis on which I was rejected. May I, Lordship, now take you to the most important document?
You are assailing the appointment of the private respondent?
Yes, respondent number 7. I'm sorry, 7. Page 53, Your Lordships. That's the minute. The interview happened on 16th of May, Your Lordships, where 3 candidates appeared, including me. The first line from the top, the board has set on 2nd of June 2023, which is after the interview process on 16th of May 2023. And they say at the second paragraph, the board has decided to follow the below mentioned principles with regards to the cutoff marks.
Yes.
Cutoff marks, which is to be followed in cases of other district subdivisions so as to maintain a uniform standard of evaluation for determining the suitability and competence of the candidate. And the process is then put here. The board unanimously decided that a total of 50% marks should be considered as qualifying marks for adjudicating the suitability and competence of the candidate. Each member of the allotted marks of 30 on the average of these marks should be considered for the final selection and appointment. If any candidate scores less than 50 marks, he or she should be treated as unsuitable. Now, Your Lordship will come 1 page before that at page 52. The first line on the top, combined evaluation sheet of the interview that was held on 16th of May 2023. So the board meeting is after the interview, and 3 candidates were called. I am number 2. My mark is 40%. The first candidate is 67 and the third is 45.6. So the evaluation that was supposed to be done on a 40% till 2002 was not carried out. Unilaterally on 16th of 15, I was not even informed that the procedure has changed. It's only when I file the RTI that I get this document, which is actually provided to me in an RTI. I come to know that the process has completely changed. In terms of this, I file another RTI, Your Lordship. So Your Lordship, be kind enough to come to page 70. I raised 2 important questions. Number 1. Number 3 is the first question that I raised. Page 70. Is there any relaxation on a qualification and experience of the appointed or an existing joint secretary? And the last question is question number 8. What is the cutoff marks followed by the qualifying marks? At page 72, they respond by saying that the cutoff mark of 40% was followed for the selection and appointment of notaries till 2022, prior to holding of the interview of Amin Gauni 2023. So this process was subsequently changed after the interview in June, which I was not even intimated. Therefore, I stand disqualified. Yeah, number 1. Number 2, the posts were 4. They chose only 1. So the candidate that has now succeeded is based on the new.
What do you mean post? These are what? Appointment against substantive
Yes,
post?
appointment.
Notary public is a
Notary.
substantive.
Yes.
How much is their pay scale?
Please.
What is the pay scale? Let us see the service rule.
Give me the.
Notary public
Page,
is just a.
Lordship, should come to
just a-
page 59 once, please.
Hmm.
Page 59.
Yes.
I would like to inform the above side, I would like to inform you that 4 number of additional notaries for the district headquarters of Kamrup, Amingaon, 3 numbers of additional notaries for the subdivision of Rongya are required in addition of the existing 3 notaries in Kamrup, Amingaon, and 2 notaries in Rongya.
So you are saying these are posts?
Yes. No, they are appointed in terms of, Lordship, come to page 41. They are not post as in this, but.
So what are
Lordship,
these?
Page 41.
Yes.
The applications are invited for selection of additional notaries in the districts of established at Kamrup, Amingaon for eligible candidate as per the notary routes and the LR Secretary of the Government of Assam Judicial Department by member dated so and so. Interested persons are requested to submit their application in the Office of Sessions at Kamrup, Amingaon in the office hours before
Mr.
57
Pukan,
and
you,
same.
you are, these.
They are
these
not post.
What are these?
There are certain requirements that are. Yeah. They, in terms of the Lordships, I just pointed out, in terms of the Notaries Act, these are actually notified by the district judge, your Lordships.
No, but that's not the answer to the question.
They are not posts.
What are they?
Page 46, your Lordships. Section 3 of the Notaries Act 1952, read with 8(4) of the Notaries Rules 1956, as amended by the governor, is pleased to appoint so and so in terms of this act. So they are actually appointed in terms of the Notaries Act based on requirements that come up in a district. So they may not be posts for the fact that they are posts which have been advertised. So as and when the requirement exists, they appointed. And this happens in terms of 8(4) of the Notary Rules 1956.
Right.
So
No, there are 3 things here.
Yes.
You have to address the court on both or all 3. First of all, if the rules have been changed subsequently, that's not a ground for the court to interfere unless you can show what is the prejudice that has been caused to you.
the entire evaluation, which was done till 2022, would have qualified me in terms of the process that was adopted. Had the process been declared that this is a new process which is going to be adopted before the interview, I would have still understood. This is a biasness which is reflected on the fact that the interview happens on 16th of May and on 2nd, by unilaterally changing a position. Now that disqualifies both of us. Now, should have been informed, I would have qualified in terms of the other process. Now, this process.
That has got nothing to do with information. It's a question of prejudice.
No, but the appointment that the procedure that was started in 2017 continued till 2022. My selection and my appointment was supposed to be based on the 2017.
Ms. Bhattacharya, what
So
you
at least that should have been intimated to me.
You obviously don't have any instruction. and
Yes,
therefore
Lordship,
would have
today I'm
nothing to
not
say.
with instruction, but
Open counsel for the petitioner. It is the
whatever he is stating, Lordship, due to pendency of the writ petition, Lordship, because the advertisement was called in the year 2017. And the board was also formed on that time, Lordship, to conduct the interview. But thereafter, there was a writ petition before this honorable court, Lordship, and subsequent. Yes, Lordship.
Assailing the selection and appointment of the respondent number 5 as respondent number 7 as the notary public pertaining to the Kamrup rural close district, Assam. The instant writ petition has been filed, primarily contending that the procedure of selection which was in vogue during the period from 2017 to 2022 has been arbitrarily changed without notifying the candidates, as a result of which serious prejudice has been caused to the interest of the petitioner. It is also the contention of the petitioner's counsel that the chairman of the selection board, namely the respondent number 6, was not competent to conduct the selection process. First of Ms. M. Bhattacharya, learned additional senior government advocate Assam, appearing for the official respondents, praised for
It's 64, my lord,
Yes.
paragraph 8.
Hmm. Yes.
But this all court, my lord, directed the commissioner and secretary, my lord, to examine the issue, my lord, and to give some weightage, my lord.
So what is that you are seeking in this writ petition?
Now, my lord, the commissioner issued, my lord, another order, my lord, page 67,
Hmm.
on the basis of report of circular officer, my lord, saying that we are not, my lord, working, my lord, as reported by the circular officer. On that basis, my lord, our claim has been rejected.
That is the order dated 3/1/2023.
Lordship.
Rejecting the claim of the
For-
petitioners for
Granting any weightage in the selection process.
appointment of Gaguras.
Lordship. And although, my lord, the circular officer issued, my lord, several, my lord, communication, page 67 onward, that we are working, my lord, under them, my lord, in various scheme, my lord. And
No, but how it can be done?
so, my lord, we are working since 2006, my lord, as per their own, my lord.
Hmm.
My lord, that my lord, that
So, my lord, minimum, we have experienced about 17 years.
All right, that we'll see later on. You tell me, you want the dismissal in 2023 or 2024?
24, my lord.
24.
Notice may go.
So,
even the lordship, may kindly see the petitioner number 6, lordships. If you are working since 2006, now his age is 30.
but he wants the petition to be dismissed in 2024. So let it be. All right. Mr. R. Ali, learned counsel for the petitioner, here's the amendments made in the writ petition, assembling the order dated 3/1/2023, by means of which the request made by the petitioners to assign weightage to the previous experience acquired by them during the time of selection as Gauguras. The instant writ petition has been filed. Mr. J. Handig, learned SC Revenue, Assam, submits that the writ petition is not maintainable in law and facts, and therefore he be granted some time to seek instruction and assail the maintainability of the writ petition on the next date fixed. In view of the above, issue notice returnable on 29th of January 2024. Since Mr. Henrik has appeared and accepted notice, who is
For 1 and 2, lordships.
for 1 and 2 and Miss
3 to 6, Lordship.
Talukdar.
8
Talukdar.
3 to 9.
3 to 9.
And it Assam for respond number 3 to 9. Service of notices. That's all, no? 3 to 9. Only 9
3 to
up to
9.
9. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the landed departmental council. First up. The maintainability of the question of maintainability of the writ petition is kept open and shall be considered on the returnable date. Parties to come prepared accordingly. So you have partially succeeded. You have at least ensured an order of dismissal in the year 2024. That should be enough.
May I please proceed? Well, in this case, my lord, we have directly impugned the order of compulsory retirement, my lord, in except K, page number 133, my lord, whereby the petitioner has been imposed the compulsory retirement, my lord. And we have challenged mainly on the ground that the complainant is who was giving the complaint, my lord, who has not even examined, who has not even asked in the departmental proceedings, my lord, for interrogation. And apart from that, in the similar circumstances, other two.
Order of major penalty will issue notice.
My lord, otherwise the statutory appeal is also pending, my lord, at page
We'll
135.
say pendency will not be a bar.
No, my lord, so direction may be issued to dispose of the said appeal, my lord, because
Then
statutory appeal.
again, I have to come, again, I have to come, I think, well,
So what is the problem?
Because page
a notice may
130.
be issued, my lord, pendency shall not be a part, that will be better, my lord.
No, let them dispose it off.
Yes, my lord.
What is the order of penalty?
Order of
Compulsory
Parliament, compulsory retirement at page 133, my lord. Then your lordship will kindly mention, my lord, page number annexure N1 and N2 and N3 and 4, my lord. These annexures, my lord, in respect of some other cases where only increments has been withdrawn and the rest of the
So we'll ask them to dispose of the appeal by taking cognizance of the materials on record. That's all. Nothing beyond that. Also, peruse the averments made in the writ petition. The petitioner herein was serving as
inspector of drugs, my lord,
inspector of drugs
at Dhemaji.
and posted at Dhemaji, being aggrieved by the order of major penalty dated
12/9, my lord, 2023.
12/9.
2023.
Page 133, my lord.
12/9/2023, by means of which order of compulsory retirement from service was imposed upon the petitioner. The instant writ petition has been filed, inter alia contending that the departmental proceedings have been conducted in violation of the procedural norms as well as the principles of natural justice and fair play, thus having a vitiating effect on the order of penalty. Mr. D.P. Bora, Learned Standing Counsel, Health and Family Welfare Department, has pointed out that the petitioner has already preferred a statutory appeal against the impugned order dated 12/9/2023, and the same is pending disposal. Stop. Having regard to the grounds taken in this writ petition, a direction be issued to dispose of this statutory appeal in a time-bound manner before a writ petition on this subject be entertained. After hearing the submission of learned counsel for both the sides, then and going through the materials available on record, I am also of the opinion that the appellate authority must be directed to consider the appeal preferred by the petitioner and dispose of the same with a reasoned order before the petitioner can be allowed to, before a writ petition filed by the petitioner can be entertained on the same subject. As such, without expressing any opinion on the merit of the claims and counterclaims of the parties, this writ petition stands disposed of at the stage of motion hearing by providing that the statutory appeal preferred by the petitioner, which is pending before the
Chief Secretary.
Chief Secretary to the Government of Assam, that is the respondent number 2 hearing, be disposed of, be heard and disposed of by a reasoned order as expeditiously as possible, but not later than 90 days from the date of receipt of a certified copy of this order. Full stop. If the petitioner continues to remain aggrieved in the matter even thereafter, it would be open for him to approach this court once again by filing a fresh writ petition. The respondent or Namkera,
I'm appearing for all the respondents.
Mr. D.P. Vora,
Chief Secretary.
Oh, sorry, not Chief Secretary.
1 and 3 to
Except two. Except two, my lord.
1 and 3 to 7. Ms. A. Talukdar, Learned G. Assam for respondent number 2.
But one small submission, my lord. I have been informed, my lord, they are going to fill up the post where petitioner held, my lord.
Doesn't matter. If you succeed, then even if they fill up, it doesn't matter. Proceedings are pending. That ground they can't take.
Yes.
They have to create a supernumerary post for you.
Yes, my lord.
Yes, Mr. Sur.
Lordship, petitioner applied for a peon post. Subsequently, she got job, worked for 3 months, and someone gives a complaint and complain that he is a higher education because he has completed higher secondary pass. The requirement was 8 pass, not beyond is allowed. But I have also seen the law and amendment was 2015 by the Guwahati High Court using the word outline bench. Number 1. Number 2, lordships, and state government also apply for peon post for higher secondary post. So purpose is the lordship is district and session judge require some person who did at least minimum education qualifications. So education qualification, when there is a bar,
not allowing for apply, that is, Lordship, something very dangerous for society. So my humble submission.
Dangerous for society.
So my humble submission, Lordships, issue notice, let them file an affidavit. And because, Lordship, I am also stating that the Article 21 also very clear, my right to live is also included. And when there is a two statute, one statute say 8 pass, another say 12 pass.
Where is the impugn order? Which page?
Impugnment is page 31, Lordship. Lordship, 34. The termination order. Only allegation, she has secretary pass.
So what is the reality?
Reality is, Lordship, he has secretary pass. There is no dispute on that. And Lordship, in the state government, I am also giving another advertisement where the 5,000 people want for a peon post, his higher secretary is required. And Lordship, the amendment of 2015, the Guwahati High Court rule, only amended that thereafter it is neither it was challenged, neither it was changed, 8 pass. So, Lordship, 8 pass cannot be a bar.
8 pass is minimum.
Not minimum, say maximum. That's a peculiarity.
Where is the rule? Let us see.
That's a, Lordship, advertisement page
17.
17 to 19. The para 3, candidate apply for the post peon must have passed 8, but candidate who have passed 12 and above shall not be applied. Lordship.
That's what I'm saying. What you are saying is wrong. Minimum is 8 pass.
Minimum is 8.
Yes. All right, we'll just issue notice at this stage.
Admittedly, it's true that
No,
high
she will
secondary-
not get any relief, but can't help it. We'll just.
Fine,
The rules are not under challenge, but.
not under challenge. And there is a notification.
All
by-
these are fixed for dismissal in 2024. Mr. Sur, you don't have a case, but.
But still, Lordship, my submission is there is a bar, but I am.
You challenge the rule.
I have seen.
You have challenged.
Lordship, in rule, my understanding of the rule.
No, your understanding is another thing. You have to
Lordship,
challenge the rule.
So what I have, rule is say that 6 ineligible 12 pass.
She is
Only
ineligible.
that has been not challenged. No,
Mr.
till
Dixit,
date.
Learned Counsel for the petitioner, peruse the amendments made in the writ petition. This writ petition is directed against the order dated 3/10/2023, by means of which his service of the writ petitioner was terminated. First up, according to Mr. Sur, the petitioner, being a higher secondary pass, her service was terminated only on such ground. Since the rules does not permit a HS pass candidate to participate in this recruitment process for filling up grade 4 posts. First up, the learned counsel for the petitioner, however, submits that the rules are not consistent with the rules followed by the state government of Assam in filling up other identical posts. Full stop. Responding to the above, Mr. H.K. Das, learned SC, Guwahati High Court submits that there is no that the writ petition is not maintainable in law as well as in the facts and circumstances of the case. The learned departmental counsel, however, prays for some time to obtain instruction and address this court if there is any inconsistency between the rules framed by the Guwahati High Court and the state government of Assam for filling up posts in the grade 2 category. In view of the above, NOM 6 weeks. So you have for all the respondents?
No, two,
He has not included BTC, but then
respondent 1 and 3, madam.
1 and 3. And who is for 2?
2 is the state of Assam, Commissioner
Talukdar,
Secretary, Judicial
Talukdar for
Department.
3. Service complete.
Deeply obliged.
Yeah, please, your lordship. Lordship, in this case, the petitioner is a family member of a disabled person as per the prescription of the lordship Assam Public Service Preferential Appointment Rule 1999. In terms of the admit card issued by the lordship authority, that is in page number 27, lordship. the petitioner appeared before the authority, interview authority. That is, your lordship will find at page number
Mr. D.
28.
Sharma, learned counsel for the petitioner, agreed due to non-selection of the petitioner for appointments in the post of peon stroke, dark runner stroke, Jugali, as advertised by the respondent authorities. White advertisement notice dated 21/1/2023. The instant writ petition has been filed. Inter alia contending that the candidature of the petitioner has been wrongly not selected. Why? Inter alia
That is, lordship, lordship, that is not disclosed. Lordship. I have filed the RT application, but no response has been received from the authority, lordship.
By inter alia contending that the petitioner has fared well in the selection process, but he has not been selected for no valid reason. Mr. R.R. Gogoi, learned standing counsel, Forest Department, Assam, and Ms. A. Talukdar, learned G. Assam, raised for some time to seek instruction in the matter. NOM 6 weeks extra copies. Highly blessed.
Badly lost. My lord, in this case, my lord, 2 times the petitioner was selected by the SP Gwalpara, my lord, for the, my lord, for filling up the, my lord, post of, my lord, deputy advisor of the village defense organization of Gwalpara, lordship. My lord, that was submitted through the, my lord, IGP, lordship, and ultimately the proposal finally was submitted by the chief controller of village defense organization of Assam, lordship, before the chief, my lord, government of Assam, lordship. Respondent number 1. Now the petitioner before you, lordship, my lord, for inaction of the respondent number 1, the respondent number 1 is sitting about the matter, lordship. My lord, as per parameter.
Mr. M.H. Chairman, counsel for the petitioner, peruse the amendments made in the writ petition. By filing this petition, the petitioner is seeking a writ of mandamus directing the authorities to appoint him as honorary deputy advisor of Village Defense Council in the Gwalpara district. Mr. Ms. A. Talukdar, learned G. Assam, appearing for the respondents, prays for some time to obtain instructions. NOM 6 weeks, since Ms. Talukdar has appeared and accepted notice for all the respondents, no formal notice, extra copies. I give her extra copies. And in 5 minutes, I'll come back.
Lost.
Branch to Bardhaman in West Bengal. It is an inter-regional transfer. The second petitioner was transferred from Agartala branch to Bardhaman.
Where
But
is
they
the
have,
order? Where is the order? Which page?
my lord, 24 is the order, my lord. These are all long stay transfer because of long stay in a particular posting. And if your lordship sees at 26, there is a status quo that 31st. Briefly, my lords, the facts are like this, my lord. Actually, my lords, on a technical plea, so far as the petitioner number 2 is concerned, your lordship will appreciate it is a transfer from Agartala to Bardhaman in West Bengal. Tripura and West Bengal is involved. If your lordship just have a look at the transfer order at page 106, it is issued by the zonal headquarters at Calcutta. 106, if your lordship sees. This, if your lordship sees the foot of the page, this is issued by the Calcutta Zonal Office. And we are really concerned with regard to item 3, list of officers who have been deployed under administrative ground and longer stay criteria as mentioned in Annexure D. If your lordship comes to page 110, Nine and 10, serial number 9 and 10, my lords, are the 2 petitioners before your writ petitioners before your lordship. And your lordship would see Guwahati to Bardhaman, though because the regional office, so far as Bank of Baroda is concerned, in Northeast area, there are 2 regional offices. One is in Guwahati and one is in Tripura, in Jorhat. Tripura and Guwahati as well as Tripura both falls under the Guwahati region. But if your lordship sees, this is an order issued by the Calcutta zone and headquarters, and if your lordship sees the at 114, so far as petitioner 2 is concerned, it is a transfer from Agartala branch, if your lordship sees at 114, Devvarna Dipankar, Agartala to Bardhaman. Only this, if your lordship sees, is an order issued by the Guwahati branch, and if your lordship sees the body, it's an inter-regional transfer of officers in response to the bank exercise seeking application from eligible officers from JM1 to MM3 for inter-regional transfer, as also exercise for inter-region transfer of officers under different criteria. It has been decided by our higher authorities, that is the Calcutta zonal. Under the regulation also, it is a zonal office which is the deciding authority to transfer the following officers of our region under various criteria as mentioned against the name. And if your lordship sees Dev Verma Dipankar, it is branch Agartala to Bardhaman. And the petitioner 1, my lord, that is at 113, his case would fall within the territorial jurisdiction because it is from Fansi Bazaar to Bardhaman. Now, a common writ petition has been filed, though these are really separate cause of action. And they have been staying as your lordship.
For the writ petitioner.
I'm for the writ petitioner, lordship.
Go and join. These are transfers you have to follow.
Lordship, that probably would have been, I have to consider on that part, but with regard to the order of transfers, the challenge that we SL is that, the two criteria has been adopted by the department, as in bank. The bank head office has exempted us from the interregional transfer because of certain personal difficulties, which is at page lordship takes up the writ petition. Lordship, the exemptions were at page 93, lordship. And
Now, on what ground you have approached this court by filing these writ petitions?
Lordship, the first ground is that as the head office has exempted us after the representation from the interregional transfer, because the reasons were given for the petitioner number 1, domicile of Northeast.
You have filed a common writ petition.
Lordship, that probably, that one part that we probably have made a mistake at the time of filing the writ petition. But the cause of action arises in Guwahati for both of them because the regional office has communicated the orders and the regional.
The cause of action is a different thing. They have separate.
That ought to happen, Lordship. That I have to consider on that. But the orders which were passed, the regional head office has passed the transfer order within 40 days of giving us the exemption for the reasons that for the petitioner number 1, his mother is ill and he is domicile of Northeast. That exemption were given on the basis of representation against the interregional transfer. As regards the petitioner number 2, he himself is not keeping well. That's why he was exempted from transfer from Agartala. Now, after 40 days, as in within 40 days, interregional transfer was communicated to us, transferring us to Bardhaman. It is in effect almost same as the interregional transfer. And the
court is not the appellate authority in this.
Lordship, but what we approach is that what they have taken, the approach was very arbitrary, as in they have not taken into consideration the representation we have submitted after the interregional transfer. And citing.
No, your name is
Dekha, Lordship.
Mr. Dekha.
Lordship.
See, this idea of arbitrariness, when it comes to the citizens in the hands of the administrative authority, is one notion.
Lordship.
And the idea of arbitrariness between the employer and employee is another notion. You can't equate the two. Right. In case of transfer matters, the jurisdiction of the courts are very, very limited. So whether to exempt, whether to withdraw the exemption, these are all matters for the employer to decide.
Earlier, my lords, it was a
Just a minute,
interzone.
Mr. Goswami. Just a minute. Just a minute. Now, apart from the technical problem in your writ petition, you submit a fresh representation. We'll ask them to give you 1 month's time.
Lordship, on the other side, if I may submit, Lordship, as the pleadings are complete, Lordship, if order is stays.
No, that is another thing. If you're If you can't make this argument, then why should we wait for pleadings are complete?
No,
Close the
Lordship,
matters today itself.
so also the question of maintainability of the writ petition on a technical ground, at this stage vacation, it may also be taken up the admission.
Mr. Deka, all I'm saying is
Not-
that there is no ground to interfere with the transfer order.
Not,
So instead of being hyper technical, on
Not-
technical ground it goes.
Lordship.
But instead of being that, we can consider giving some time to your client
Lordship.
to join.
Lordship.
And in the meantime, you can also appraise the authorities about your personal difficulties. But if they don't want to take it, you have to go and join. The courts will not come in. If they do not consider your grievance, you will have to go and join. We can't substitute the decision of the authorities. That's between you and your employer. We can't help it.
Lordship, allows us to submit the representation, and until disposal of that representation by the petitioners, they may be allowed to hold the post, the status quo may be maintained as it is passed in the order of 31-7, Lordship. The order under, we'll file a representation within 3-4.
You have not filed any representation.
We filed it, they have disposed it of, Lordship.
Then
Lordship, it's fallen from the Lordship to file fresh representation to consider once again. So if that may be allowed to us.
No, the point is, if they don't want to consider your case, then what can be done by the court? These are transfers.
That is,
you are in a transferable service.
Lordship,
But what can be done?
What we highlighted before in the writ petition is that the order which was passed by the head office exempting us, the situation hasn't changed, and they in effect has transferred us. The regional office has transferred against the in the situation there's prevalent. They have transferred us to another region which is equivalent to transfer to the interzonal transfer. They have equated both.
No, but head office and regional office are not.
Zonal office has passed that order.
They are all the same.
Lordship will allow some time to explore on that part, and maybe on just reopening of the vacation. Lordship allows us to come back and submit on those points. Lordship, I'm just making a prayer with that. Immediately on reopening, Lordship.
All right, Mr. Goswami, till
Hey,
third-
my lords,
third January.
what fell from your lordship, they may make a fresh representation. We will consider within a time bound as directed by your lordships. Until then, if your lordship so pleases, they may be, but we'll then take a fresh look if your lordship so pleases.
Lordship, that could also be done, Lordship.
Then you consider, but
Otherwise, Lordship, on third, if allows us to come back and submit.
then
Lordship.
My lord, otherwise on merits today also I'm ready, my lord. Your lordship just have to look at the
merits,
regulation.
it's not very convenient, Mr. Goswami.
No, it is an incident of transfer. That is why instead of troubling your lordship, if they
We
want to
see
file a
going very deep into merits is.
that is why your lordship may give them an opportunity to file a fresh representation, and we'll deal with that, my lords, and pass
Lordship
on.
will allow us to come back on third, Lordship. That would be.
All right, take your seat. Heard Mr. D.K. Goswami, Learned Senior Counsel appearing for the applicant. Also heard Mr. D.
Deka.
D. Deka,
Lord.
D. Deka, Learned Counsel appearing for the opposite party, stroke writ petitioners. This IA has been filed with a prayer to vacate the interim order dated.
31-7-2020.
Which page is it? Page number?
Page
24 of the IA, Lordship.
24.
Dated 31-7-2023, passed by the learned single judge in WPC number 4328 of 2023. Directing the respondents to maintain status quo as regards the transfer order dated 27-7-2023, issued by the General Manager, Kolkata Zonal Office, pertaining to both the writ petitioners. Full stop. It appears from the materials on record that the petitioner number 1, the writ petitioner number 1, that is, what is his name?
Devopriya, Lordship.
Devopriya Datta, was posted as
Your lordship will
MM3 level officer.
Middle management level 3.
Middle management level 3 officer at the Fancy Bazaar branch of the Bank of Baroda, and the petitioner number 2, namely Mr. Dipankar Dev Burma was posted at the Agartala branch of the bank, also as a MM3 level officer, by issuing two separate transfer orders dated 19/7/2023. Both the petitioner number 1 has been transferred from the Fancy Bazaar branch and posted at Bardhawan, whereas the petitioner number 2 was transferred from the Agartala branch of the bank and posted at Bardhawan. The grounds of transfer in both these writ petitions have been cited as within court, longest stay. Assailing the aforesaid orders of transfer, the two writ petitioners had joined together and approached this court by filing WPC number 4328/2023, wherein the learned single judge had passed the interim order dated 31/7/2023. Arguing in support of the stay vacating application, Mr. Goswami and his senior counsel for the applicant has argued that there is reasonable ground for the authorities to transfer the petitioners since they have spent long years in the same place of posting, contending that inter-regional transfer is permissible as per the bank's policy. Mr. Goswami submits that there is no justifiable ground for staying the transfer orders passed by the authorities in case of the petitioners. The applicant's counsel has also questioned the maintainability of the writ petition itself by contending that the two transfer orders having been issued in different circumstances and giving rise to two separate cause of action for both the writ petitioners, they could not have approached this court by filing a common writ petition, more so when the grounds on which the transfer orders are being resisted by the petitioners are distinct and different from one another. Responding to the above, Mr. Deka submits that on a request made by the writ petitioners, the zonal office,
The head offices.
the head office of the bank had already granted waiver to both the petitioners in respect of
Interzonal transfer.
in respect of interzonal
Transfer.
transfer. Inter-regional, no interzonal.
Lordship, the first one is interregional, the second one, this will be interregional. Exemption is from interregional and the transfer was interregional, which is under challenge.
Then interzonal transfer. But within 40 days of such exemption, the impugned orders of transfer have been issued. It is also the submission of Mr. Deka that both the writ petitioners are facing personal difficulties, as a result of which they are not in a position to move out from their respective places of postings. It is on such ground they had submitted representations before the authorities. Full stop. However, the same have not been considered.
There has been
So
considered.
that has been
The order
disposed
one.
of, my lord. Page
After
132.
Submitted before the authorities
Rejected.
after the impugned order of transfer were issued. However, the same were rejected without considering the genuine difficulties facing by the petitioners. Full stop. It is settled law that transfer is an incident of service, and the jurisdiction of the writ court in matters of transfer of employees within the organization is extremely limited. Full stop. The writ court would be justified in interfering with the order of transfer only when the same is issued with a mala fide intent or in violation of the statutory norms or the professed policies of the organization. Full stop. In the present case, there is nothing to show that the transfer order impugned in the writ petition have been issued in contravention of any of the above conditions. Full stop. It may be correct that the petitioners are facing some difficulties in their personal lives, which may make it hard for them to comply with the order of transfer. However, whether such hardship is sufficient to modify the order of transfer is a matter which would always lie with the domain of the employer. Full stop. Full stop. At this stage, Mr. Goswami submits that if the petitioners submit fresh representations highlighting their personal difficulties, the authorities will consider it in a time-bound manner before taking any further steps for implementing the transfer orders. Full stop. In view of the above and having regard to the peculiar facts and circumstances of the case, this IA as well as the writ petition are being disposed of by granting 10 days time to both the petitioners to submit individual representations before the zonal office.
That will be before the regional office because that is forwarded through the regional office to the zonal office.
No, who is the authority? To the head office of the
Head
zonal
office, zone.
submitters.
No, head office will consider. You
My
can't
lords,
say
my
it is
lords. The
head office.
zonal office in Calcutta under the regulation is the authority.
Sorry?
The zonal office in Calcutta would be the competent authority.
Zonal office at Kolkata, zonal office of the bank at Kolkata, West Bengal, to be routed to the regional office, expressing the difficulties faced by them by producing relevant facts and supporting documents, if any. Full stop. On receipt of such representations, the same be considered on merit by the authorities and disposed of by a reasoned order. Full stop. Until such time the aforesaid exercise is completed, the impugned orders dated both dated 19/7/2020 shall not be implemented. With the above observation, these matters stand disposed of.
Right.
Deeply obliged, my lords, deeply obliged.
Acha, with the consent of learned counsel for both the sides, the IA is being taken up for disposal along with the connected writ petition being WPC number so and so.
Deeply obliged.
Deeply.
35, implement of parties.
Right, my lord, the respondent number 8A, my lord, to be, my lord, implemented as respondent number 9, who has been, my lord, holding the, my lord, pensionary benefits of the, my lord, petitioner.
Holding the pensionary,
My lord,
told it.
pension has been released, my lord. It has been, my lord, deposited.
Have you demanded compliance?
Yes, my lord.
Where is it?
Lordship will find at page 9, my lord, in the IA.
Heard Mr. M. Mondal and counsel for the applicant, none appears for the respondents. His IA has been filed with a prayer to implead the present incumbent in the post of Treasury Officer, Nagaon, Treasury Office, Nagaon, as respondent number 8A in the connected contempt case on the ground that he is responsible for implementation of the court's order. First of Mr. Mondal submits that the aforesaid opposite party is withholding the pension to be paid to the petitioner without any rhyme or reason. Full stop. Having perused the statements made in the IA, and after hearing the submission made by Mr. Mondal, the prayer for impleadment is hereby allowed. Sri Manoranjan Gohai, Treasury Officer, Nagaon, Treasury, Nagaon, is hereby impleaded as respondent number 9, is it?
Nine.
Respondent number 9 is the, not 8A, respondent number 9, the connected contempt case, petitioner to file amended cause title in the contempt case within 10 days from today. Whereafter, the contempt case be listed for orders. With the above observation, IA stands disposal.
Obliged.
Lordship, I have for impleadment, your lordship, to the proposed respondent number 4 and 5, your lordship, page 3. We have duly intimated, but base 10 is the dismissal clause.
You want to include whom?
Lordship, this is the additional, now the present incumbent, Ravi Shankar Prasad, additional Chief Secretary, and Niru Dalai Gupa, Secretary to the Government of Assam, and Mr. K. Yadav, case 3 and 4, Your Lord.
Why you want to implicate them?
They have presently holding the post to the Lordship.
What is the direction of the court?
Direction of the court, Your Lordship. In the contempt petition, Your Lordship, direction was issued to Your Lordship. Page 14 is, sorry. Page 10 is the order, and page 11 or 12 is the party part, Your Lordship. My departmental proceeding was not initiated, Your Lordship, and subsequently my promotion was held up because of that, Your Lordship. And accordingly, direction was issued, Your Lordship, to the respondent, Lordship.
Let's see, where is the, you are appearing for whom?
Forest Department, Lordship.
There is no forest department in a contempt case.
Lordship, the respondents, all the
Respondent.
respondents.
Hmm. Where is the order of the court?
Lordship, page, party page 12, page 10, starting order.
Page 10.
Lordship.
So who is the disciplinary authority in your case?
Is the secretary, Lordship.
Secretary. Then why you want to implicate 3 of them?
Lordship, because direction was issued to the respondent, Your Lordship, there is no specific order to the respondent because they are only respondent of the
There is no direction. The direction is only to the disciplinary authority.
Lordship.
Then why have you implemented 3 officers? Why you want to implicate so many officers? Hmm? No, there must be a reason. Is there a reason, or you have just filed it without applying your
Because
mind?
the earlier in original petition, 3 petition contempt.
That's not a consideration.
That is the
Only 1 officer can be opposite party in this case, not more than 1. You already have 3, you want to add another 3, why?
Lordship then picks up on Wednesday, Your Lordship.
Yes, but I think it's better you withdraw it and file afresh by giving the reason.
Lordship.
Because in this court, reasons will matter
Lordship.
if you want to do it. Otherwise, there will be difficulty.
Lordship.
Contempt cannot be diluted in this matter. You put in herds of officers and then.
Only 1, Your Lordship. Only 1 will be
Yes,
the
you
member.
give your reasons
Lordship.
why the others were implemented earlier and how it has changed and why you want to implement the officer. You tell us. Mr. L. Mohan, counsel for the applicant seeks leave of this court to withdraw this IA with liberty to file afresh after carrying out necessary modifications in the court, in the application. Mr. I. Bhattakur, yes. And a counsel is present for the respondents. You file an fresh and we'll take care of it. But why aren't you, in the contempt case, why aren't you disposing of
Lordship, a part of the order has been complied with. His promotion order has been kept on seal. Only Lordship, one last procedure where views from APSC has been sought. That part, Lordship, has not been
All right,
completed.
in the main contempt case, you read hard Mr. L. Mohan Lanak, counsel for the petitioner, also heard Mr. I. Bothakur Lanak, counsel appearing for the respondent.
Respondent one, Lordship.
Respondent number one, who submits that the order of this court has been partly complied with by disposing of the disciplinary proceeding. Is it? Inquiry
Lordship, proceeding is not disposed as such, but the formalities are complete. Only the last stage is.
Has been partly complied with by expediting the disposal of the disciplinary proceeding. But insofar as the prayer for granting promotion to the petitioner is concerned, opinion of the APSC has been sought for and the same is awaited. Mr. Bothakur, however, seeks 2 weeks' time to obtain updated instruction and appraise this court on the progress made in the matter. They are allowed on the request of Mr. I. Bothakur. This matter is directed to be listed again on 8th of January 2024 as a fixed item.
Lordship.
May it please your lordship. Lordship, petitioner had filed a writ petition seeking for release of pension arrears. Accordingly, on 1st of November 2022, this honorable court was pleased to pass an order directing the concerned authority to verify the service details and pay the arrears within 5 months. Lordship, the order was not complied with and a contempt petition was filed. Lordship, in the contempt petition, respondent number one, that is the commissioner, GMC, they have filed an affidavit in opposition stating that upon receiving the said order, they had informed the accounts department and they have calculated the arrears of 430 petitioners. But due to the inadequacy of the funds, they are not able to release the pension arrear pensions. Lordship, they have also annexed 2 letters in the affidavit in opposition addressed to Commissioner and Secretary, Housing and Urban.
You want to implicate whom?
Housing and Urban and Finance Department, Lordship.
Okay. So have you demanded compliance of the order from them?
Yes, yes,
Where is the
Lordship.
proof?
Lordship, paragraph number 3.
No, the proof, the document.
Lordship, since in the affidavit in opposition in the contempt petition, they have said that since the budget is not released by the finance department, they are unable to release the same to the petitioners. So we want to implead them since the...
No, if you want to implead someone in the contempt case, then the law says you have to first approach and demand compliance of the court's order.
Yes,
If they
Lordship.
fail to comply, then only you can implead. Impleadment in a contempt case is not like impleadment in a writ petition. So have you done it? That's what.
No, Lordship, as per my knowledge, we have not written any representation.
Then this IA will not be maintainable.
Lordship, you might give me a one date. I'll confirm with my petitioners and.
All right. So you check it.
Yes, Lordship.
We'll have it day after tomorrow.
Yes,
If you have not demanded compliance, then you do it.
Yes, Lordship.
Withdraw it and do it.
Yes, Lordship.
And then you come back.
Okay.
Because contempt proceedings follow a certain norm. They'll come and say that we didn't know, nobody asked us to comply with the order.
Yes, Lordship.
You have to do that. You see
I'll
some
confirm the same.
judgments where these things have been settled. Your name, please?
P. Gupta.
On the request of Ms. P. Gupta, Lanak counsel for the applicant, this matter is directed to be listed again day after tomorrow, first to enable her to obtain instruction. Mr. S. Bora, Lanak counsel is present on this sole respondent.
Much obliged.
Please, my lord. My lord, this is an application under 468 of the Companies Act 96. My lord, the respondent directors appeared before the official liquidator and they've submitted the documents. Thereafter, the official liquidator is now preparing a report. Once the report is ready, my lord, we'll file the report and then the matter may be taken up.
We have complied with all the requirements set forth by the official liquidators. So there is a change in my lord man in position, therefore they are sitting sometime.
That's why he's taking some time to prepare the report.
Mr. R. Barbajari, Lanak counsel appearing for the respondents in both these cases submit that pursuant to the order of this court, his clients have appeared before the official liquidator, bracket OL, O/L, bracket close, and submitted all the requisite documents. Mr. Sandelia, Lanak counsel representing the OL has confirmed the said position, but contends that in view of the change of the incumbent in the office of OL, there has been some delay in preparation of a report we submitted before this court. Mr. Sandelia, however, seeks posting of this matter again after 4 weeks so as to enable the OL to present the report. Prayer allowed, list the matters accordingly.
Right. Here in this case, Lordship, the affidavits, I have to file the affidavit in response to the petition.
What is the matter about it?
Matter, Lordship, it is the departmental proceeding dismissal, Lordship.
Department compulsory retired, Your Lordship. I was working as a junior administrative assistant in the office of the senior government advocate, Your Lordship. There was a departmental inquiry, and in the inquiry, I was found guilty, Your Lordship. And then an order was passed for my compulsory retirement. I filed an appeal.
What is the charge? What was the charge?
It is page 50, Lordship.
50.
The query is not what is the page number of the charge. The query is what is the charge.
Lordship.
Please respond to the query.
Lordship. The charge number.
All right, it seems both of you are prepared for adjournment. You are not aware.
Lordship, I need an file an affidavit, Lordship, therefore needs it.
TW Learned Counsel appearing for the petitioner also heard Mr. J.K. Goswami, Learned Additional Senior Government Advocate Assam, who prays for and is granted another 4 weeks time to file affidavit. Let the matter be listed upon.
Yes.
Lordship, instruction is awaited, Lordship. And the father of the petitioner died in the year 2015, Lordship.
May I submit, Lordship? And the matter relates to compensation and appointment. Lordship, in this case, what had happened and that district level scrutiny committee has approved, has recommended my name to the state level scrutiny committee. But the state level scrutiny committee sitting over the matter for 3 years has rejected my claim, stating that 3 years has already elapsed, therefore your compensation appointment cannot be granted, violating the norms of 2015, Lordship. Kindly peruse page 58, Lordship.
No, but why you don't have instructions?
Lordship, it's on the second time it has come, Lordship.
Gotcha. Second time, third time, how many times?
Lordship, 5
5 times, then
no,
you-
no, Lordship, I apologize, Lordship. DLC, we have received the instruction from DLC. SLC is awaited, Lordship. On short date maybe.
No, but you sit over the application, the time goes and then you say that,
No,
that is not what we will appreciate.
No, Lordship. We need instruction. It may be earlier also, it may be considered, Lordship.
One last chance.
Lordship.
After that,
Lordship.
heard Mr. P. Bordole, Learned Counsel appearing for the petitioner. Also heard Ms. A. Talukdar, Learned G. Assam appearing for the state. Ms. S. Sharma, Learned SCPWD is present on behalf of the
3,
department.
5, and 6.
Uh,
3, 5, and 6.
The grievance of the petitioner pertains to rejection of his prayer by the SLC for appointment on compassionate ground. Mr. Bordole submits that it is the SLC which sat over the matter for 3 years and thereafter turned down the request of the petitioner for appointment on compassionate ground by citing delay as a reason,
Lordship.
which is wholly unreasonable. Ms. Talukdar, however, submits that instructions are still awaited. Be that as it may, considering the nature of controversy issued in this writ petition, this matter is directed to be listed on 22nd of January 2024, so as to give one final opportunity to the Departmental Counsel to obtain instruction and file affidavit, facilitating disposal of the writ petition.
DP obliged, Lordship.
Obliged.
Supplementary list for admission item 6.
My lord, a similar matter is fixed on this Thursday, my lord. The matter relates to, my lord, a contractual employee, my lord, the Panchayat department. I'm engaged as Gram Rozgar.
What is the case number?
My lord, the case number is, my lord, 4182 of 2023.
4182.
82 of 2023.
Mr. R.M. Dekal and counsel for the petitioner submits that as similar matter being WPC member 4182 of 2023 is fixed before this court on
2112. my lord.
21/12/2023, and therefore this matter be tagged together. In view of the submission made by Mr. Decker, registered to tag this case along with W1 41 WPC 4182 of 2023 and list the matter again on 21
Deeply applied.
21/12/2023. Yes.
Item 43, my lord.
Yes.
That was in admission, my lord. That similar matter was sent.
Lordship, I have received the instruction in Lordship, here also in this matter, he was examined and then re-examined. Lordship, both the time his disability was found to be 30%, not 40%.
But
So, Lordship,
The same order.
no,
same order.
my lord, he joined his service and my lord,
Joined
thereafter
for-
he was terminated, my lord.
Lordship,
Something different, my lord. My lord, if he joined in employment, my lord, then section 20 will apply, my lord. Then arbitration.
You take out that item, you take it out. We'll have it tomorrow then.
yes, Lordship.
Then, my lord.
The
And
record is gone.
and in one other matter, my lord, there is an appointment order, my lord. There is a order pass holding by joining, my lord. There is
All right, item, you are mentioning item number?
item, my lord, 58, supply this 58. R40.
Tomorrow.
Lordship, in that case, Lordship, Lordship, he has placed his report, Lordship, medically. I am the appointing authority. Lordship will tell me sometime, I'll make it.
Let it come up tomorrow, then we'll see. This item 43 and
Supply 58.
supply 58. List these matters tomorrow. On the request of learned counsel for the petitioner, that list these matters tomorrow. The learned departmental counsel to come prepared with instruction.
Highly obliged.
Obligement.
For orders, item 44 and
Excuse me, my lord. My lord, in these applications and application under section 481 of the Companies Act, a dissolution report has been prepared by the official liquidator. It's being filed in the course of the day.
common order list tomorrow.
My lord, the same, the report is being filed in the course of the day today. My lord, and let it come on record, then my lord, maybe be able to.
Mr. S. Sanilya, learned counsel representing the official liquidator, bracket O/L, submits that the report of the liquidator will be brought on record during the course of this week. Therefore, this matter be posted after the winter vacation along with the report. Prayer allowed, register to do the needful and list the matter again in the third week of January 2000. List the matters. Oh, well.
May I please, your lordship?
Yes.
Lordship, the respondent authority filed an appeal, writ appeal against a single bench order. So these matters may be tagged. Otherwise, lordship, contempt
Who
is
is for the
for
respondent?
or contempt is against for non-compliance of the order dated 26/2022, and relevant portion is paragraph 19.
Paragraph 19.
Yes, no. Paragraph 19, page number 23. Yes.
So who is appearing for the respondents?
Mr. D not is for contempt against the respondent authority. State. Earlier, they filed a review petition also, but that was dismissed on the ground of delay.
Are you aware what has happened in the division bench?
Yeah.
How do you know there is an appeal preferred by the state?
Notice was issued.
Actually, you have received notice.
Yes, yes, Lordship.
But nobody is appearing in a contempt case. Mr. Talukdar, where is Mr. Nath? If he doesn't appear, then we'll have to call his officers. No? Mukesh Shahu and Vivas Modi, we'll have to call him. If he comes in 5-10 minutes, otherwise we'll summon the officers. Contempt case, there is no way out. Just wait for 5
Yes,
minutes.
Item 49.
May I please, your Lordship? Lordship, matter may be fixed for hearing.
Lordship, we have received instruction, Lordship, we'll be filing affidavit.
Has been admitted. What is the matter about?
This is regarding dismissal from service, Lordship.
Okay. Miss
RS, your Lordship.
RS Learning Council has appeared for the petitioner and submits that since the challenge in this rate petition is against an order of dismissal from service, the matter be fixed for expeditious hearing. Ms. M. Bhattacharjee, learned government advocate Assam, appearing additional senior government advocate Assam, appearing for the state respondent, submits that within 6 weeks, affidavit on behalf of the department will be brought on record. Be that as it may, after hearing the submissions of the parties and on going through the materials available on record, this court is of the opinion that this writ petition would call for deeper hearing. As such, admit the writ petition. Since the respondents are already represented, no formal notice is required. Registry to list this case for final hearing as a fixed item on 5th of March 2024. The respondents may file their affidavit on or before 21/2/2024 by serving advance copy upon the petitioner's counsel, the learned departmental counsel to produce the records on the next date for conducting hearing of this writ.
Obliged, Lordship.
Obliged, your Lord.
May I please, Your Lordship? Petitioner's brother was killed by the Moro miscreants, Lordship, in the year 1890, Lordship.
Lordship, I am appearing on behalf of Counsel G. Bordello. He has some personal difficulty. He's the counsel for cooperative department. I have been instructed that no copy has been served upon him.
May fix the matter.
All right, Mr. K. Kolita, learned counsel for the petitioner is present. So also is Mr. C.K.S. Burwal, learned GA Assam, appearing for the state. However, the learned standing counsel of the cooperation department submits that due to want of extra copies of the writ petition, he could not obtain instruction. In view of the above, please let this writ petition be listed again after 4 weeks. In the meantime, extra copies of the writ petition.
Fix a date, Lordship.
Learned SC.
Lordship may fix a date.
Cooperation, 4 weeks, after 4 weeks. Okay.
Pending matter item 47 to 48.
Yes.
But here, we have preferred a writ appeal, and that in the writ appeal, notice has been issued. The respondents have also appeared in that case. I have the copy of the order, my lord.
But is there any stay order?
There is no stay order, but considering pendency, my lord, kindly give us some time, my lord.
Time for what?
My lord, the writ appeals are coming up, my lord. My lord, we have a prayer for stay.
No, Mr. Nath, the point is,
Notice
merely because writ appeal has been entertained, that doesn't mean the order of the single judge should not be implemented.
My lord, the honorable court has issued notice in the appeal as well as in the interim prayer and made it returnable in 6 weeks. The respondents have appeared. Mr. B.P. Bora, he appeared. I have the order copy, my lord. He appears in the writ appeal.
Lord, considering that, my lord, tendency of the interim prayer in the appeal, kindly give us 2 weeks time, my lord. Let it, this case be taken up after 2 weeks, my lord.
All right, you are appearing in which case?
I am appearing in item number 47.
Item 47 and 48. Ms.
R. Dr. Lordship.
R. Dr. Learned Counsel for the petitioner in item 47 and Mr. PJ Dr. Learned Counsel for petitioner in item 48. Mr. D. Nath, Learned Counsel representing the respondent submits that writ appeal has been preferred by the state against the order of the learned single judge, and the stay prayer is pending consideration before the division bench. As such, Mr. Nath seeks posting of this matter again after 4 weeks so as to enable him to obtain an order from the division bench, failing which consequential orders may follow in this case. Taking note of the submission of Mr. Nath, these matters are directed to be listed again after 4 weeks. About 49.
One lordship. Lordship, in this matter, our affidavit is ready. We are not able to.
Actually, What has happened in this matter?
Just now I have received the reply, lordship.
No, affidavit, today we have filed lordship. This is the regarding. the-
1 week, immediately after vacation will be distributed.
All right, Mr. G.J. Sharma, counsel for the petitioner, submits that a copy of the counter affidavit filed on behalf of respondent number.
Lordship, Water Resource Department, Lordship.
Give me the respondent number.
Lordship.
Respondent number 2 has been served upon him only this morning, and therefore 10 days time be granted to obtain the instruction and file rejoinder if so advised. Mr. R.M. Das, Learned Standing Counsel, Water Resources Department is present. On the request of Mr. Sharma, this matter stands adjourned for 2 weeks.
Okay.
My lord, in this case, my lord, I am on behalf of the writ petitioner. He filed a IF for issuing appointment letters. My lord, we want to file a affidavit in opposition to the IA, my lord. Maybe given some time.
All right. Mr. A. M. Ahmed, Learned Counsel is present for the applicant. Mr. A.R. Sikdar, Learned Counsel for the opposite party writ petitioners prays for and is granted 10 days time to obtain instruction and file objection opposing the prayer made in the IA. Registered to list this case again after 2 weeks.
My progress. May it please your lordship, my lord. My lord, here, my lord, IA has been filed for consideration. My representation at page 34, my lord. My lord, the DP has been, my lord, pleased to be stayed, my lord. And after that, my lord, I filed this representation for allowing or for revoking the suspension order. But there is no review of the suspension, and my lord, they have not considered this representation. My lord, in page 38, I have given the grounds, my lord, that this representation may be directed to be, my lord, considered, my lord.
Which representation?
Page 34 in the IA, my lord, Annexure 8, 30/11/2023, my lord. This is to the secretary, my lord, to the governmental person. Revocation to allow me to continue. My grounds basically is page 38, my lord, last paragraph. It appears that the search memo dated 19/2023 was issued after 108 days of issuance of suspension order. Dated
What is the challenge in the writ petition?
Writ petition, my lord, because the in the DP, my lord, charge was that I was arrested in a criminal case
And I was, my lord, therefore, since you were arrested, therefore, why disciplinary action shall not be taken against you? And my lord, this service in the DP and the criminal case here in the FIR I have given, my lord, page 15 is absolutely ditto and same. The FIR is of 12/4, my lord, and my lord, they have initiated DP.
So what has happened to the charge sheet?
Charge sheet, my lord, that order, my lord, I enclose, my lord, that has been pleased to stay, my lord. By order dated page.
What do you have to say,
28.
Mr. Snack?
Lordship, one search sheet was issued on 9/10/2023, Lordship.
Hmm.
And it is his submission that the criminal case, charges in the criminal case and the charges in this search sheet are same. And on that
But
basis,
would you
Lordship,
like to file any objection here?
yes, Lordship, definitely, Lordship.
Then they are entitled to an opportunity.
Yes, my lord.
I heard Mr.
Yes.
B.K. Das and counsel for the applicant.
In the IA, my lord, my lord, since my representation is pending, my lord, in the meantime, there may not be a bar for considering this representation, my lord.
Maybe, Lord.
Or,
Yes, Lord.
or, my lord, in my humble submission, IA may be disposed of. I have not asked for anything, my lord, for disposal of my representation 3011 in the IA.
No. If depending on his stand, if he fails to file, then we'll pass that order. Pays the statements made in the IA on the request of Mr. P. Nayak Leonard, Standing Counsel, Finance Department, Assam. This matter is directed to be listed again on 5th of January 2024.
No, I'm praying little more time, Lord.
No,
My lord, I
Why
already
you
understand.
are going somewhere?
Bihu vacation, Lord.
No, my lord, it will be difficult.
After
Let
the
me,
Bihu
my lord, sir, before.
He's getting subsistence, Lord.
No, that is also not been paid, my
My
lord.
personal
75%.
Why you are going somewhere?
Lordship, probably, yes, Lord. After
Then
Bihu,
ask someone else to handle it. He also
no, Lordship, I have to file the objection. That is.
file it by 5th.
Yes, my lord.
Hmm.
Before.
You may have some difficulties, but the things have to go on.
My lord.
Otherwise, we have to, then you obtain instruction. Day after tomorrow, we'll dispose it of the IA.
No,
For cons-
Lordship, the main case is pending. Lordship,
Yes.
I'll file an objection. Lordship will.
Why don't you file it by 2 days? We'll take it up on Thursday.
2 days it will be difficult.
No.
Lordship. I will not get the instruction. Lordship.
Because, my lord, they have
Then I
not
can't
paid.
help it. 8th of
Oh,
January.
that's-
On 9th, Lordship. On
On
9th.
9th of January, so as to enable the learned standing counsel to file objection opposing the prayer in the IA. The prayer made in the IA will be taken up for consideration on the next date.
Oh, bless. Definitely.
54.
Yes, what is this? Who is appearing? D. Sinha. No. Chalo, pass over for the time being. All.
May it please, your lordship. We have already taken steps for service upon the respondent number 5, your lordship.
Service upon respond number 5. What has happened? Notice served.
Office note does not reflect that, but only shows that notice has been issued. In the meantime, let them file the affidavit.
Then we'll await service report and respond number. Mr. M.H. Laskar, counsel has appeared for the petitioner, Ms. M. Bhattacharjee, learned additional senior government advocate Assam, is present.
1 to 4, Lordship, and we have received instruction. We'll be filing affidavit.
And submits that she has received instructions and therefore be granted 3 weeks time to place the same on record in the form of an affidavit. In view of the above, then you write, office note indicates that service report and respond number 5 is still awaited. In view of the above, let this matter be listed again after 4 weeks with appropriate office note. In the meantime, the official respondents may file affidavit.
Interim order may be continued.
Interim order passed a date. Then make it 6 weeks.
Obliged, lordship.
Already had it 6.
May it please, your lordship. My lord, the matter was adjourned on the last occasion, enabling the counsel for the T board, Mr. Keal, to obtain necessary instructions as regard the promotion.
So your client gets the promotion.
I do not know, my lord. I have not been informed.
No, we'll record, this is the instruction. Promotion order will be issued. Will,
Your lordship in that case may have it after the vacation. I'll speak instructions.
no, why after vacation? We'll ask them to issue the promotion order. We'll record their submission and ask them to issue promotion order.
No instruction in that case, whether he would like to pursue the petition
All
or
right,
not.
heard Mr. Datta Learned Senior Counsel appearing for the writ petition. I also heard Miss
M. Deca.
M. Decker, Learned Counsel appearing on behalf of Mr. S.C. Kyle, Learned Counsel representing the T board to submit that the writ petitioner herein has already been selected for being promoted to the rank of Deputy Director in the T board, and the order of promotion would be issued shortly. First up, Miss
N. Mahanta for respond number 5.
N. Mohanto is present on behalf of respondent number 5. At this stage, Mr. Datta Learned Senior Counsel for the petitioners is for posting this matter immediately after the winter vacation so as to enable him to obtain updated instruction. Prayer allowed. Registry to list this case again in the second week of January 2024 so as to enable the petitioner's counsel to obtain instruction.
Finding matter, item 54.
None appears for the petitioner even in the second call. This matter therefore stands passed over for the day.